Today's daily course list. Delivery of order item 1.
These matters will have to wait because we don't have enough. We'll fix it. We'll have it. Right. Mr. Majumdar, next week you will have it. We'll have it listen and then we'll pass.
What is it? Blessed. Top of the list item 5.
My Lord,
You are now keeping well, Mr.
yes, my Lord, I am grateful. I have
No, no.
expressed my deep regard and respect to you for accommodating me
Come on.
for a few
When
days
when a
so
council
that
is
I
not
can
keeping
get an
well,
opportunity to submit before your Lordship in this matter.
we are also very eager to hear this matter.
Grateful, my Lord.
Can you give me a preliminary
Right.
as to what you want?
My Lord, in this writ petition, only one point is involved.
Hmm.
That is regarding release of the pension and leave encashment.
Right.
And as your Lordship knows that there are 3 retired benefits: gratuity, pension, and leave encashment for all employees. Government employees or private, it is there. Yes, I need not elaborate to your Lordship. So in this case, my Lord, fortunately, gratuity has been released by the order of the Honorable Justice Ujjwal Singh. 50%. I can place the judgment. Thereafter, my Lord, Honorable Justice Suman Sam had released a balanced 50% judgment.
No, Mr.
That is also on record.
I just want an
Huh,
overview.
huh.
What you
Balanced
argue.
50% judgment.
Okay.
Acha. So on the basis of that judgment of the Honorable Justice Ujjwal Bhuiya, my respectable submission is that pension and leave encashments will also be released. If this, ask this question to myself, my Lord, or why? When Regulation 22, bank is harping on Regulation 22. 22 is clearly telling that when there is a dismissal, removal, compulsory retirement, pension shall be forfeited. Section 22. But what Section 22 has taken away from the employee has been returned to the employees
By the
by
IRA.
pension regulation of 41 to 48, my Lord. On the basis of this, that whether there was any loss for the bank due to the act of misconduct of the delinquent employee, or he has been accused of any serious crime involving moral turpitude. But this is not the case. Here, unfortunately, what happened, the employee is a branch manager. The government of Assam has given certain subsidy. Bank has stipulated the condition that loan will be sanctioned and subsidy will also be kept there. And if the loan became bad, some amount of subsidy will be recovered from that loan, 50% or something. But loan could not be sanctioned because farmers were not inclined to take loan, and the manager also was a little bit scared that if the loan became bad, what will be happening? So he did not release the loan. By that way, he could not release the loan. Then there was a pressure from the BDO and the Assam government. He released the subsidy, and he released the subsidy. So this subsidy money does not belong to the bank. This subsidy money belongs to the
Government.
Assam government. So he has returned the subsidy money. Bank say it is a technical fault. It is a technical fault. Why you return the subsidy to the farmer without sanctioning the loan? And punishment has been imposed on the basis of removal from service without any disqualification as per Section 4I of the Discipline and Appeal Regulation. My Lord, so if your Lordship...
Mr. Adhikari,
Yes.
Sarva Adhikari. Here the issue is that you have tried to project from escape pools
My
judgment. Is that forget your regulations. Now that there is a settlement between the management and the Indian Bankers Association and the workmen, that will have prominence. So under that, if you have that stipulated service, then even if it is removal or dismissal, provided there is nothing to be recovered from you, you will have to be paid the amount.
Grateful.
So I just want your submissions on this point, that when normally we say that when there is a regulation, that will hold the fee. But here, industrial dispute comes in and there is an agreement. Now, kindly address me as to between these two, bringing in SK Cool, how the agreement would have predominance than the regulations. This is the issue I want.
So, my lord, if your lordship kindly go through the Honorable Justice School's judgment, that judgment clearly stipulates that both the officer's pension regulation and the bipartisan settlement has been harmonized. And the bank in his affidavit also mentioned it. May I place that affidavit?
Mr. Prabhadikari,
My lord,
just to
School's
understand the
judgment,
issue,
I can place.
what I am
Yes,
trying
sir.
to understand is, in Pool's judgment, in the opening paragraph, if you can just give him that Pool's
Hmm.
judgment. In the opening paragraph, you will find that the penalty was with pension.
Right, my lord.
Now, if that stipulation is not there, the Supreme Court also went with that view. If that stipulation is not there, what would be the effect? Or would you try to argue that even if that stipulation is not there, the agreement, that will hold the thing? Kindly clear this doubt first.
My lord, but apart from the settlement, the regulation has a statutory effect. Settlement is between the employee and the employer.
Ah.
So it has no statutory effect, my lord.
Ah.
You got it.
Ah.
But the regulation has statutory effect.
Ah.
And if your lordship kindly look to
Pension rate.
the judgment of the Honorable Justice Ajil Amba and Suman Saikia, I can place it.
Kindly,
It is
is it on record?
absolutely clear. I can place
Is
it.
it on record?
It is there. Because it is not there, I can give this judgment. If your lordship kindly go through.
This is something
Ah.
which was troubling me.
Yes. Because this is the regulation which has the statutory
Statutory
force.
force.
Settlement has no statutory force, my lord. And but Honorable Justice School, in Cool's judgment, Honorable Justice Prasad has harmonized these two regulations. That, and moreover, the officer of the employees of the bank, that I will also show you from the regulation. After your lordship kindly go through the Honorable Justice Lamba's judgment. There is a specific direction of Honorable Justice Lamba to the bank that you come with clear standpoint about this school's judgment.
Okay.
And now
Forfeiture of
kindly go
service.
through his
Resignation
affidavit,
of
next page,
business.
paragraph 3. Bank has specifically mentioned in the affidavit that the two regulation has been harmonized. If these
Shall
two
entail
regulation has been
forfeiture.
harmonized,
Consequently, from a plain reading, it is evident that removal shall entail forfeiture and presently shall not, if we have to accept or employ removal from such by any of them. But the fact of the matter is that bipartisan settlement provides for a removal from such a settlement. We do under the regulation prevailing anti-war. Consequence of the construction would be that the words quoted above becomes a dead level. Such construction has to be avoided. Does not entitle every employee of insurance, Okay, after this, an affidavit has been filed.
yes, affidavit, paragraph 3 of the affidavit, my lord. Bank. There also, short paragraph, the bank admitted that the two regulation has been harmonized.
Okay. So they question that you are not a workman.
method.
Okay. So basically, before me, the issue is only one of harmonizing the
My lord.
various things.
And if your lordship kindly go through the Honorable Justice Ujjwal Bhuiya judgment, there Honorable Justice Bhuiya has been exclusively dealt with section 22 and come to the conclusion that since bank has not sustained any loss, because of that, he is entitled to the at least 50% of the gratuity pending his other writ petition there. And Honorable Justice Suman Sam has directed to release the balance 50%, of course, without interest.
Okay, got it. Now, what is the material to show that you are not a workman? You are a workman and you are covered by that tripartite settlement.
I am not covered by bipartite settlement but I am an employee. I am an employee. The pension regulations, if your lordship kindly go through it, pension regulations say Punjab National Bank's employees pension regulation.
1995.
That pension regulation.
Regulation,
And-
how much you want to, which one you
regulation.
No, regulation is there. Which one you want me to peruse?
Then my lord, kindly come to Punjab National Bank discipline and appeal regulation, my lord. I am referring to
Mr.
discipline and appeal regulation where,
Sir, here.
it is there, my lord. I am
To
uh,
entails forfeiture. Okay.
to page 237, my lord. If your lordship kindly come to 1, 2, and 3 of the Allahabad Bank Officer Employees Discipline and Appeal Regulation.
Just yesterday I found that somewhere.
Last portion of the booklet, or otherwise I can place
No,
this
no,
one.
no, no, it's here. I
Yes,
read
it
it.
is there.
I read it. In your compilation, it is there. Employees discipline. and appeal.
Yes.
Yes.
Punjab National Bank Officer Employees Union. These regulation may be called Punjab National Bank Officer Employees Discipline and Appeal Regulation. That means officer is also an employee.
To all officer employees of.
Officer employee. Officer employee.
But
Then my lord, coming to paragraph 2. This regulation shall apply to all officer employees of the bank, but shall not apply to 1 to 6. Then my lord, I invite your lordship kind attention to
Mr. Sarvadikari,
3J.
No. Sarvadikari, when we are in 2,
Yeah.
can you just dilate on 2.5? Award staff.
Award staff means the person covered by award staff as defined in the Industrial Distributor Banking Companies Decision Act 1955.
So can they take this argument that persons who are covered by awards, means
Award staff.
this IBA will also be a sort of an industrial dispute thing. They'll be excluded from this.
So far pension regulation, my lord, concern is only one pension regulation, which is applicable to both
Oh.
our staff and to employees. There are no two separate.
No.
So if this pension regulation is applicable to the our staff and also the officer, so there cannot be any distinction between our staff and officer in the bank's pension regulation.
No, that's what I'm trying to understand.
Right.
2.5 is an exclusionary clause. It excludes.
Yes.
And it has excluded award staff. But it has applied it to all other if I may use the word, non-award staffs. You come within that non-award. So
No,
you will be,
pension regulation is applicable,
no, pension regulation does not. It's equal to all,
it is applicable to all.
all. But here, this discipline,
Here,
Hmm.
officer has been also categorized as employees. Otherwise, this definition would not have been there. Punjab National Bank Officer Employees Discipline and Appeal Regulation. This regulation will be called Punjab National Bank Officer Employees. That means
for the-
officer are also employees.
no, for the
Yeah,
understanding.
but
for the
they are not governed by our staff because of the Industrial Dispute Act, where Industrial Dispute Act specifically mention, as your lordship knows, that if a supervisory position is there and certain amount of salary is up there, he will not be covered by Industrial Dispute Act.
That's what
But here, they have not distinguished between employees and officer in the officer discipline and appeal regulation.
What? a
That is
query-
my humble
I
submission.
know, understood.
Yeah.
Query, whether this word officer, employee is two word or it means officers are also employees.
Officers are also employees. That is my, and this will be coming from paragraph 1, paragraph 2, and then my lord, 3J. Officer employees means, this has been covered because of the Industrial Dispute Act. 3J. Officer employees means a person who holds a supervisory, administrative, or managerial post in the bank, or any other person who has been appointed who is functioning as an officer of the bank by whatever designation call and includes a person whose service or temporary place at the disposal of the government. So this two regulation has to be again harmonized, my lord. The officer bank did not distinguish between officer and employee so far terminal benefits are concerned.
Correct.
Because our staff also are entitled for three benefits: gratuity, pension, and leave encashment. Officer employees are also
Same,
entitled the same benefit, and they are covered by pension regulation, which pension regulation, my lord, it is regulation 43 to 48. Categorically mention, my lord, that if there is no loss, then pension has to be given. That apart, my lord, I shall place banks one circular, my lord.
We'll come to that. We'll come to that. We'll go details. Just getting a preliminary thing. Can you come to the definition of employee in the pension regulations?
Yes, my lord. Pension regulation, my lord.
Two, it's two N. So if we look into this, here there is a separate definition for all. Employee, any person involved in the service of the bank, whether as a workman. So workman
What?
on full-time work or permanent basis,
Right.
or on part-time work on permanent basis on scale wages,
My lord.
or as an officer and who opts and is governed by this regulation. So there is a both
Employee
updated
or officer?
Hmm?
The word or, employee or officer?
or officer.
Or. Emphasis is on or. That means employees or officer both are covered, my lord.
And you
Otherwise,
want
the
me
word
to-
or would not have been there. I am grateful, my lord. You have hit in the
You want me
Correct
to
point.
go to then 40? How much did you say?
41 to pension regulation, 48, my lord.
41 to 48, unfortunately, is not here. It's here till 36.
43, 44 to 48,
It's not here. It's,
I
you have given me till 36.
pension regulation, my lord.
Let me see if there is a copy.
I have
Is
the-
there in, is it in
I
your
have a
compilation?
compilation.
Then is it here in the compilation? Council, is it here in the compilation?
Pension regulation,
Anyway, I also have it.
No, is it in the compilation?
it is,
I
No,
have
no,
a
that is
separate,
not that pension regulation separately. Previously I have given.
it's till 30.
Entire one. I have given the, I'm giving the entire pension regulation. From page 15 onwards till page 81.
Or is it, oh, you have
Yes,
given
this-
me a written.
Yes, yes, this has up to regulation 56.
Okay.
That should be fine.
Mr. Sabadekar, you are taking me to 40?
43 to 48, my lord.
It's 73 on.
73.
73.
43 to 48, my lord.
I have not touched this. so-
48 categorically mentioned.
43, okay. Withholding or withdrawal of pension.
Hmm.
In order, right, withhold the pension of part thereof, whether permanently or special pension is converted in a serious crime or criminal breach of trust or forgery or acting fraudulently or is found. Convicted so and so shall be taken in light of the judgment. In cases not falling under regulation 45, considered the prima facie guilty, if the prisoner shall follow the procedure of so and so or in settlement as the case may be. That on 18 days of superannuation, or otherwise, so and so, so and so, so and so, so and so, is given a provisional pension, expression, so and so. Commutation of pension during departmental or judicial process. Recovery of pecuniary loss, recovery of bank dues. Okay,
2-3 points more, my lord. Your lordship has already got the point. Now, my lord, I rely on the bank's own circular dated 25, 2014, my lord.
It's
Page
available.
228.
it's in the compilation,
It is there.
220.
228 page number, the circular dated 25, 2014. Bank's own circular.
Which compilation? Today's compilation or the earlier compilation?
Earlier complaint.
220,
8, my lord, here. Page
it's
marking
regulation
maybe-
27, appendix 4.
Hmm.
It's a circular.
It is a bank's own circular, 25, 2014.
And page number?
Page number here, my lord, possibly 228.
Not 220. What is the-
Something
what is the
will be
date of the
different.
circular?
So
What
I
is the
can
date?
place my
No,
copy.
no, date of the circular?
My lord, this is Punjab National Bank Provident Fund Pension Department, HO Rajendra
Circular.
Palace, New Delhi.
25, 2004.
My lord.
25.
25, 2014.
It is 243.
214, my lord, right, sorry.
243.
214, grateful, my lord.
Payment of gratuity in cases
Yeah.
where services are terminated by so and so. In cases of where removal of employees are terminated by way of so and so, they may or may not be any loss. Time of settlement of so and so, department raises query as to whether the aspect has been written. So and so, notwithstanding anything contained gratuity or services have been terminated, so and so, so and so, so and so, so and so. Okay.
Then, my lord, next page,
Hmm.
middle paragraph. This is most important. Moreover, the board of directors,
Hmm.
by this resolution number 9 in meeting dated 25 and 26/7/2014, has also desired that ordinarily full pension be allowed to the employee in case no reference regarding reduction in terminal dues by disciplinary authority in the final order is made. However, where the disciplinary authority makes a reference in the final order to reduce pension, matter be placed before the competent authority as per pension regulation, my lord. This has not at all been followed. And disciplinary authority has not directed any reduction of the pension regulation or forfeiture. Simply is removal without disqualification for future employment.
Now.
So
now,
that means,
Savartikar, one more question.
yes, my lord,
The pension regulations is a salutary thing.
my lord.
This is an opinion or a desire of the board of directors. Whether this provision was included in the pension regulation or you say
Yes,
that.
yes, it has been mentioned in the pension regulation that competent authority shall take the decision. Competent authority has been defined in the pension regulation and regulation 48, it
I'm-
has
I'm
been
not-
mentioned.
I'm not on that. You have taken me to 43, 44, 45, 46.
Right.
Wherein there is a requirement, the disciplinary
Yes,
authority
in
feels-
in that regulation, there is a requirement that competent authority will decide that pension and leave encashment or terminal benefits should be written.
No. What I get from here is that there is no reduction. There is no reduction.
No forfeiture also.
No forfeiture, nothing.
No.
No, forfeiture is a different question. Just understand.
Forfeiture by separate regulation, my.
No. If in the pension regulation, it says that if you want to withhold or withdraw a part of the pension, you can pass orders under that.
My lord.
Now, here, what we are considering in the regulation, in the communication of circular of 2014 is the board of director, because there is a provision in the pension regulation that removal or dismissal forfeiture. Now, in that context, they have taken a decision or they have desired that ordinarily giving full pension. That means any case which is not covered under 43 to 48, you are entitled, even in spite of removal or dismissal, you are entitled to full pension.
Right.
They are bringing in the bipartite settlement. Now, my question is, was this provision or this desire incorporated in the pension regulations?
In pension regulation, it has been mentioned and section and regulation 22 is become a dead letter because of the Honorable Supreme Court judgment.
Cool.
And I cool judgment, and thereafter another judgment I have filed, 3-bench judgment, Radhasyam Pandey versus
Pandey.
State Bank of India.
Mm.
There it has been mentioned on the basis of the IBS circular, the regulation 22 should be amended. And
It was
Punjab
never
National Bank has amended it.
Who?
Punjab National Bank has amended it.
That is what I want. Where is that?
Yes,
amendment?
that in judgment of the Honorable Justice, I have mentioned, I have given you the,
That is what I want.
Yeah.
Where is that?
it is in the, one moment, my lord. Assistant General Manager, others versus Radhasyam Pandey, page, my lord, in here, my lord, it has been 674, but paragraph 41 and 22 of that judgment is very much relevant.
Radheshyam.
Radhasyam Pandey versus State Bank of India.
It is available in the earlier compilation.
Earlier compilation.
I think I've read it. Yes. What is it? What is the citation?
Citation, my lord, I have taken it from NET.
No problem. No problem.
I have taken it from NET.
Can you just give me the page number where it is?
I am giving,
In your compilation page number.
yes.
I got it.
Yes,
Got it. Paragraph
Paragraph 22 and paragraph 41, my lord.
22 and paragraph 40. Government of India suggested to idea to amend the regulation.
Paragraph 22, rather paragraph 21, 22.
IB may work out modalities and such required in the pension to ensure that the employees get pension. The letter of this so and so to and so to and so. Add paragraph.
And paragraph 41, my lord. The IBI advised the bank and they are down below. Punjab National Bank has implemented this regulation. So, my lord, this 22 is a dead letter.
No, that is what I was looking.
So, this is.
The IBA advised the banks by amending the rules. Government of India so and so issued a proposal to amend the rules of a scheme of so and so, including so and so. The nationalized bank, including Punjab National Bank, amended their rules with retrospective.
Punjab National Bank amended their rules in 2002.
So to amend the rules for the government to amend its rules of implementation. Okay.
And then, my lord, Indian Bank Association, why this has been occurred, that I have also enclosed. Indian Bank Association, on the basis of Honorable Justice School's judgment, has directed all the nationalized bank
Bank.
to amend the
That
regulation
is
20.
there in page 41.
Yes, yes, it is there.
Para 40.
Para
That you took me now.
Yes.
Para 41, it is there.
Yes, it is there.
Is a letter from the government of India.
On the
Followed
basis
by-
of that, IBA taken a decision, directed the bank, we amended section 22 rules and released that pension. And the judgment I have placed, it is only general principle of law, your lordship, that pension is a social benefit, is no employee should be that, you know, right from Tata Iron. That I need not repeat at least to your lordship.
Nakara and all.
I have given so many judgment, but I don't think it is requires to be looked into because of the regulation specifically mentioned.
Mr.
And last
Savarikar.
but not the least, my lord,
Hmm.
about the gratuity has been mentioned.
Mentioned.
But bank circular specifically mentioned that
Gratuity-
gratuity should be released with
gratuity-
interest, and section 4 of the interest act say there. If your lordship feel that interest should be paid to the delayed payment of gratuity, I leave it to your
No, I'm
lordship.
not on
I
that.
am not claiming, because previously honorable judge has
The-
not given this
The,
interest.
the yardstick for gratuity follows from the Gratuity Act.
Okay,
And therein there is a provision that if there is no loss
Right.
determined,
right, my lord.
then gratuity normally should not be withheld
Withheld,
if you have that 5-year plus service.
my lord.
But when it comes to pension, the
Yes,
entire gamut
absolutely
would
correct,
change.
my lord.
Entire gamut would change.
Yes.
So we have
So
regulation
that's,
22.
well, the thing is all right.
We have regulation 22.
But
From
regulation.
regulation 22, we have to now understand cool, IBA, this is pension
Rajasthan
regulation,
Pandey's judgment
Radhesham Pandey's judgment.
and Devkinandan Paddas constitutional bench judgment, that is also
Vivekananda.
on principle of law.
Can you just take your seat? I'll just ask.
Yes,
you.
yes, yes, my lord.
Yes, Mr. Gandhi.
Great.
Now, the issue last time was, the confusion last time was just a preliminary thing.
No,
Please, just don't find that I've taken a final year, just having a preliminary.
no.
Last time my confusion was when the regulations, I think that was we were deep. When the regulations have a salutary force, it has to hold the field. Be whatever the agreements and all are there, if it is not inbuilt into those, that may not be. Then I had a doubt with SK Cool. SK Cool, therein being a stipulation that this would be that.
Yeah.
Now, Lanak Senior has placed Radhesham, be that as it may, there is a paragraph 41 that you have in terms of IBA amended your regulation.
I do not have the benefit of that judgment.
I'll
The
give it. to you.
Regulation
I
22,
have given to you.
41.
Page 41, have you taken it?
You can take this. You can have this.
No, I can give it to you. My lord, you need not trouble, I am giving it to you.
So if 41, para 41 says that in terms of the
Hmm.
government, first is a government of India letter. You come to para 22 first.
Para 22 and
I was stuck at this point on the last occasion.
I am
really stuck
giving my
on this.
copy, yes.
No, Mr. Savarikar, you
Yes.
were not here, but last occasion, this was the point that I was stuck in.
Correct. my lord.
So I was not being able to come out.
Yes, yes, yes.
Para 22, that is page 66
Page টা মিলবে না, para 22
go to page 66 of this compilation.
compilation.
para 22 টা দেখুন, পেজটা মিলবে না।
The pages may not match.
No,
para 22
Para 22, if you can just go through that.
yes.
Suggested to IBA to amend regulation so and so that the employee do not so and so may work out modalities if required be made. That letter is being quoted here, right?
No. But if your lordship comes to para 41, my lord, we think what is mentioned here is, my lord, if I may read para 41 again.
They have referred to a VRS.
They have also referred, my lord, to a letter dated 5/9/2001.
That
to the bank.
5/9, you will find it at page para 22,
No.
that is quoted. But if you go through that,
No.
there is another ingredient there. It refers to a voluntary retirement scheme.
Yes. And well, here it is said that there was a proposal to amend the rules after the scheme was implemented in 2000. The nationalized banks, including the Punjab National Bank, amended their rules in 2002 with retrospective effect.
Hmm.
The rules that I have placed before your lordships are amended up to 31/7/2003.
No,
Whatever
we
this judgment
will
says.
go by the prescription in the judgment. That we will have
Definitely,
to.
my lords. But regulation 22,
But,
as
but,
per
but
my
Mr.
instruction,
Ganguly, why I'm telling you,
lordship,
whether this is an application, this will have an application also in a
In cases of-
departmental,
in case
departmental,
of, yes, my lord, it will
that,
not, my lord.
that you will have to just examine.
Lordship.
Because it says here, circulation,
about
no objection for
VRS.
circulation of so and so, the scheme inter alia provides employees with 15 years or 40 years shall be eligible so and so as per the provision so and so. An employee can take after 20 years of qualifying, therefore, thereafter become eligible for pension. Thus, employees having rendered 15 years of service, so and so, but not having completed 20, shall not be eligible for pension benefits. Whether it is in this light that the amendment was made,
No, this appears to be related to VRS, my lord, not to termination or
that's-
disciplinary actions.
that's it.
And that is why, my lord, that is why I'm saying that the rules and regulations that we have been placed, this is up to 31/7/2003, amended up to 31/7/2003. Here, as per the judgment placed by the learned senior counsel, says that there was an amendment in 2002. Had it been
No,
amended in-
amendment may be in that provision with regard to VRS, because it
Yes.
says that the rules also
So,
provide for VRS.
Regulation 22, as per my instruction, is still on the.
No, I'm not on that.
It is
You
not-
just find out from that regulation where the provision for VRS is there, if
Yes.
any amendment was made. Why I'm telling you, if the bank has made an amendment to
Yes.
that portion only,
Lordship.
that means this part was never touched.
Lordship.
Mr. Odegari,
Yes.
now we can go whole hog.
Grateful, my lord.
Now you can go whole hog. The
Grateful.
cowbells
Because
have been-
my labor has been much reduced because your lordship has already got the point. So now I leave it here and regarding.
No,
on-
just give me the factual background.
Yes, on the same principle, my lord, leave encashment is also, I have mentioned.
you get
If it is
pension,
never,
if-
leave encashment is entitled.
If we come to a conclusion that you are entitled to pension,
So he
leave
is entitled to
encashment
leave
will
encashment as a-
automatically come with.
Grateful, my lord.
It would be
Although I
the-
have given the two High Court judgment which has been confirmed in the case of Commissioner Rao as well as Calcutta High Court judgment where I appeared. So there also the leave encashment has been allowed with interest because no loss is there.
Can you just take me through the facts? Because I'll have to declare,
Yeah.
you can just take me through the facts. Facts of the case,
Yeah. Regarding,
the whole facts, just the,
facts of the case, my lord,
Hmm.
the writ petitioner was a manager
Hmm,
in the branch.
hmm.
Their government of Assam has given certain
No, you can
subsidy.
take me through the documents, that will do.
Huh.
The charge
So
sheet-
these are there.
Hmm.
So but the fact is that he did not release the loan, he did not sanction the loan, but returned the subsidy under direction of the BLRO. That document is there in my.
Mr. Odegari, I got it. You just
Yes.
come to page 18. Let's start off from there. Page 18,
Page?
18 of your writ petition.
Hmm.
That is the show cause charge sheet.
Just to interrupt you, if I may, my lords, regulation 28, I think, my lord, in the compilation also that I have given, that was amended, my lords.
And that
Chapter
this
5.
provision was brought.
Yes, and the entire story is narrated.
There.
there. I found just that.
That's what I want. Yes, manager, then he was subjected to a department proceeding. Did it start from page 18 of the writ petition?
Page
18.
18 of my notes of
Writ writ petition.
writ petition, my.
I just want the
petition
facts.
is not here is with me. Anyway, if it is there. Original writ petition has been dismissed.
Okay.
It is dismissed because original writ petition is dismissed. They are there. That's why when appeal has been filed on legal advice, he did not press for that.
Uh-huh.
What he did is, he desired for release of the terminal benefit
Right.
and file an affidavit. On that basis, Honorable Justice Ajil Amba and Honorable Justice Suman Saikia
Limited.
passed this order. That
So now we are on a very narrow compass.
narrow compass, right, my lord.
The penalty that was imposed on you, by the order 59/2013
Yes,
has attained finality. And the penalty imposed upon you was removal from service.
Removal servings 4I of the disciplinary appeal regulation without any disqualification. And as your lordship knows, two penalty cannot be imposed, double jeopardy. That I need not explain. Because that is also another penalty, recovery from the pension. That is also there in the regulation.
Now, after this,
Hmm.
you put this to challenge in the present proceeding.
Yes,
Just
by
putting
way
it-
of writ petition was dismissed, against
Then
that
you went
appeal
up
has
for
been
appeal.
preferred. But ultimately, we did not press the appeal. Instead, we filed a supplementary affidavit with the leave of the court, and out of that, the judgment of Honorable Justice Ajit Lamba and Suman Saikia has been come. Thereafter, Honorable Justice Julia, after hearing me,
Hmm.
ordered that no, it should be decided by a writ court because this has not been agitated before Honorable Single Bench.
That is an order dated 21/4,
Yes.
2021.
By Honorable Justice Julia. During Corona period, after hearing on virtual hearing.
So para 3 there.
That it should be decided by your.
Counsel for the so-and-so submitted that he is not challenging the legality of the appellant's removal from service. His argument now is limited to the extent as to whether the appellant is entitled to superannuation benefit such as pension, leave encashment and gratuity. In support of his new contention, he relies upon the bipartite section.
Yes.
Okay. And this bipartite settlement was holding the field on 5/9/2013 also.
Yes,
So only that issue we are required to now
Yes.
consider. Okay. And what are these papers? Okay, these are, they will not go into the charge because the charge is already taken care of. The charges have already been taken care of.
yes.
So now I'll have to look into your compilations.
There, my lord, I have given a few judgments. Of course, three Supreme Court, okay, one of Cool, one of Justice Rajasthan Pandey, another of Devkinandan Poddar. This is a constitutional bench judgment. There also pension has been held on the basis of principle. And other two judgments I have given of Honorable Calcutta High Court and Madras High Court regarding release of the gratuity. Of course, gratuity release, leave encashment on the same principle. So of course, Supreme Court, few more judgments I have given Tata Iron, Sudhir Kumar Sarkar, Sasikala, because these are repetition on the same principle. That pension is a social benefit. We have to release this pension. In a socialistic country, this is the moot question in all these three, all these Supreme Court judgments. And two single judge benches, these are also based on
It's-
Supreme Court judgments.
That's it.
Simply, that leave
And
encashment
today,
should
this
be.
compilation that you have given me,
Yes, that
this
is
is
regarding
the,
their affidavit.
And-
And it is a short summary of my big notes of argument. That's the second one. And there I have given the Honorable Justice Ajay Lamba's judgment and another judgment of Supreme Court again.
Delhi.
Same principle that it is a social benefit, pension cannot be forfeited under any circumstances. Two judgments I have given.
Radhesham Shukla, Radhesham Pandey, he was also an employee or a officer.
Officer, my lord, honorable writ court decision also I have enclosed. In my second compilation, I have enclosed the honorable writ court decision.
Ah, you have put it in very lucid terms. Good.
Mhm.
Your point of argument is here.
See, that is 1997 fourth Supreme Court, S.C. Agarwal and G.B. Patnaik, Honorable Supreme Court. This new compilation I have given, same principle, my lord. I need not repeat that pension should not be withheld under any circumstance.
That is that Delhi,
That is there.
S.C. Agrawal and Justice G.B.
S.K. Agarwal and G.B. Patnaik.
Very good.
Internal page
Now
435.
we have got the hang of the matter. Don't worry.
Internal page 435 on one.
Subject to Mr. Ganguly. Yes, Mr. Ganguly. Please have a seat.
Yes.
So you got to only satisfy me.
Yes. No,
That-
that's why in my compilation, I have only
That
given.
just this thing.
Okay.
Just to understand, I'm a little bit slow in understanding. What we have culled out from what Mr. Sarvadikar is trying to project is that forget 22. According to him, that is a dead letter. Supreme Court decisions and all. He comes to the pension regulation and he says the definition is also inclusive of an employee and an officer, both or. So they are together. So in that view of the matter, maybe his argument with regard to 43, 44, 45, 46, maybe that may not be much acceptable. Because that is again a different penalty, is of withholding. That's a different penalty altogether. Here it's a question of forfeiture, not withholding or
No.
Withholding can be 100%, can be 10%. Forfeiture is a different question altogether. It's a different ballgame. He is trying to make an advance an argument. Let's see. He refers to para 22 and 41 of Radheshyam saying that, see, you have already done it. And this already done is from that IBA settlement.
Yeah.
So the doubt still persisting is that letter refers to a voluntary retirement scheme.
Yes,
And you tell me that 28,
yes.
which
I'll-
relates to that, has been amended.
Yes,
Now, will you be arguing before this court that 22 not having been touched, that will continue to hold a field, at least for the purpose of an officer, of a person who is not an award staff?
yes,
An award staff would be covered by that IBA,
yes. Bipartite, settlement.
right?
Yes,
Continue.
yes. No, first of all, that is why I have annexed the bipartite settlement in my compilation. If your lordship will I'll only stick to the compilation. I'll try to stick to the compilation because nothing much is required.
It's a pure question of law now.
Pure question of law, then it's very evident, and even I think my learned senior has not pressed seriously the point that he is a workman. So if he is not a workman, then bipartite settlement benefits as per SK Cool and.
No, he has an
subsequent-
argument for that. He has brought in your definition
Lordship.
to include officer employee.
Definition is correct. I agree with him, my lord.
No. He is advancing an argument
Lordship.
that officer employee,
Yeah.
when it is together. So that's why I asked him whether these are two words or one word.
Lordship.
He said it is single. Officer is an employee. We'll have to read it in that manner. So if it is an employee,
Lordship.
then the definitions, other definitions kick in, and he says, I'm covered by the bipartite.
Bipartite settlement.
Now you take.
Lordship, if your lordship will come to the bipartite settlement itself, which I have given at page 2, my lord. My lord, memorandum of settlement, if I may read, dated 10th April 2002 between the management of 52A class banks as represented by the Indian Banks Association and their workmen as represented by the All India Bank Employees Association, National Confederation of Bank Employees, Indian National Bank Employees Federation. My lord, this agreement, this settlement was between the banks and their workmen, my lord. Employee, I agree with what Mr. Sarvadikar is saying. Employee includes both officer and workman. Bipartite settlement benefits will only be to the employees because of the obvious reason, my lord, it was meant as a social welfare, my lord, because they.
Come down, read that under.
Yes, lordship was also referring to, my lord, the other day that section 18. It would amount to an award under section 18. So it would supplant, my lord, what is there in regulation 22. So if he is a workman, no question, my lord, we don't have a case, he is entitled to the benefits of bipartite settlement as was rightly stated
But
in.
Mr. Ganguly, a similar offense by an employee, workman.
Yes,
A cashier would be a workman,
cashier would be workman.
workman. And a manager,
Yes,
both misappropriates
yes.
equal amount.
Well, the constitutional validity of this regulation 22, because it is not there only in PNB, Malad, it is there in various other banks. This has been assailed in certain high courts. Certain
Okay.
high courts have refused to Malad, enter. into
What,
that.
what, did it go travel to the
And-
Supreme Court?
Malad, not to my knowledge, because this is, as of today, regulation 22 exists. It is there on the statute book and we have to deal with it. And I shall show Malad that the Supreme Court has held that regulation 22 will apply in a case of forfeiture. There is no need for the bank to go to regulation 30, 43, 44, 45, 46, 47.
Need not, that
That is, it's
a
no
settled
need, and it
position.
is
That
automatic,
need not
Manoj.
be.
That is why
that
we
is-
say regulation 22 is automatic. The moment you are terminated, dismissed, removed, it comes into play immediately.
Okay.
It takes away the benefit.
Sorry, I'm interpreting.
No, Manoj,
Go ahead.
I'm grateful. Manoj. So, Manoj, the first point is that the bipartite settlement is only and only restricted to workmen. If he was a workman, then Manoj, he'll be entitled to full pensionary benefits. Then Manoj, Lordship has already gone through this regulation 22, so I need not detain your Lordship with that. But as far as the regulation 28 was concerned, Manoj, Lordship will kindly have page 40 of my compilation.
The correct word would be not officer, but a supervisory staff.
Lordship.
Okay. Page?
Now, page 40, effectively it starts at page 42, Manoj. This is the amendment that was done, Manoj, which my learned senior friend is referring to, Manoj. This is, Manoj, chapter 5, classes of pension. Superannuation pension. Superannuation pension shall be granted to an employee who has retired or is attaining the age of superannuation specified in the service regulations or settlements. Provided that with effect from 1st September 2000, pension shall also be granted to an employee who opts to retire before attaining the age of superannuation, but after entering service for a minimum period of 15 years in terms of any scheme that may be framed for such purpose by the board with the approval of the government. Now, there is an explanatory memorandum, Manoj. Indian Banks Association, after taking a no objection from the Government of India, circulated a model voluntary retirement scheme, VRS, to all the public sector banks on 31/8/2000. The scheme inter alia provided that employees who have rendered 15 years service are eligible for the scheme. According to the existing provisions in the regulations, it is only employees who opt for voluntary retirement after completing 20 years of qualifying service and after giving notice of not less than 3 months in writing to the appointing authority are eligible for pensionary benefits. The eligibility criteria and the benefits flowing out of the above provisions in the pension regulations are distinct and separate from that envisaged under VRS circulated on 31/8/2000. There are no provisions available in the pension regulations for extending pensionary benefits to a member employee who retires before attaining the age of superannuation under such specific schemes. It has therefore been decided to provide the benefit of pro rata pensionary benefits to members of pension fund who opt for VRS under specified schemes. It is therefore necessary that the amendment may be made effective from 1st September 2000 so that all employees who are members of the pension fund and have taken voluntary retirement under the scheme after completion of 15 years of service can draw the benefit of pension. It's certified that no employee or officer of Punjab National Bank is likely to be affected adversely by the notification being given retrospective effect. So this was the amendment, Malot, that was made, and that was only because of the fact that there was a discrepancy, Malot, occurring between those who were applying earlier, going for voluntary retirement. So they mandatorily had to, Malot, go through 20 years of service and give advance.
That is
3
your
months.
29.
Yes. And even otherwise, Malot, regulation 33 onwards also, Malot, there is a provision for compulsory retirement pension.
That's a penalty.
Not necessary for the
That's a
present.
penalty.
Lodge.
Fine, next.
No, Malot,
So Radheshyam, application is 28, not 22.
not 20.
Okay.
Manoj, 43 to 48, I think my learned senior has already gone through. Manoj, I will not take up your lordship's time for that.
Hmm.
Manoj, SK Pool is very clear, Manoj. SK Pool, if I may have page 83 and this judgment onwards.
Hmm.
By Mr. Manoj. SK Pool, respondent number 1, since deceased, was working as a clerk with the petitioner Bank of Baroda, and while working as such after a departmental inquiry as a measure of punishment, visited with the penalty of removal from service with superannuation benefits as would be due otherwise and without disqualification from future employment.
Hmm.
Now, let's SK Cool, hereinafter referred to as the employee, made a request for leave encashment which was declined by the petitioner Bank of Baroda, hereinafter referred to as the employer, on the ground that where cessation of service takes place on account of the employee's resignation or his dismissal, termination, compulsory retirement from the bank service, all leaves to his credit lapse. The employee laid claim for pensionary benefits, but the same was also declined. However, the employee advised the employee to ask for sanction of compassionate allowance not exceeding 2/3 of the pension which would have been admissible to him otherwise. A dispute was raised and the company government referred the dispute for adjudication by the industrial tribunal. So, my lord, subsequently, it was referred to the industrial tribunal. Now, if your lordship will have the next page 84 minutes. If I may read para 7. Mr. So-and-so learned senior counsel appearing on behalf of the appellant bank submits that the employees of Bank of Baroda are governed by the Bank of Baroda Employees Pension Regulations 1995, hereinafter referred to as the regulations. According to the learned senior counsel, the regulations have been made in exercise of the powers conferred by clause so-and-so of the Banking Companies Acquisition and Transfer of Undertakings Act 1970 after consultation with the Reserve Bank of India and the previous sanction of the central government. The regulations, therefore, in his submission are statutory in nature and in terms of regulation 22(1) of the regulations, removal of an employee from the service of the bank would entail forfeiture of entire past service and consequently he shall not be entitled for pensionary benefits. According to whom such an employee at the most would be entitled for compassionate allowance in terms of regulation 31 of the regulations. According to Mr. Gupta, clause 6B of the bipartite settlement provides that an employee found guilty of gross misconduct may be removed from service with superannuation benefits, that is pension and other provident fund and gratuity as would be due otherwise under the rules or regulations prevailing at the relevant time and without disqualification from future employment. But this in his submission would not override or supersede regulation 22(1) of the regulations, which in no uncertain terms provides for forfeiture of the entire past service on removal from service. Any interpretation other than that, what has been suggested by him, would obliterate regulation 22(1) of the regulations content, Mr. So-and-so. Ms. So-and-so, learned counsel so-and-so, well, if I may just read the operative parts. The bipartite settlement was considered, my lord, para 12 onwards. In 2002, a bipartite settlement was signed by the Indian Bank Association and the Bank's Workmen's Union with regard to disciplinary procedure. It is common ground that in the light of the said bipartite settlement, clause 6B was inserted as one of the punishments which can be inflicted on an employee found guilty of gross misconduct in the same reads as follows. An employee found guilty of gross misconduct may be removed from service with superannuation benefits, that is pension and or provident fund and gratuity as would be due otherwise under the rules or regulations prevailing at the relevant time and without disqualification from future employment. The employee undisputedly has been visited with the aforesaid penalty in terms of the bipartite settlement. So, my lord, the bipartite settlement provides that he will get, my lord, the benefit of pension, provident fund and gratuity. So, my lord, a workman under the bipartite settlement is protected by clause 6B, my lord. Even if he is removed, terminated, he gets the pensionary benefits. Now, my lord, para 13. Regulation 22, my lord, this is regulation 22 again. From a plain reading, next paragraph of the aforesaid regulation, it is evident that removal of an employee shall entail forfeiture of his entire past service and consequently such an employee shall not qualify for pensionary benefits. If we accept this submission, no employee removed from service in any event would be entitled for pensionary benefits. But the fact of the matter is that the bipartite settlement provides for removal from service with pensionary benefits as would be due otherwise under the rules or regulations prevailing at the relevant time. The consequence of this construction would be that the words quoted above shall become a dead letter. Such a construction has to be avoided. The regulations do not entitle every employee to pensionary benefits. Its application and eligibility is provided under Chapter 2 of the regulations, whereas Chapter 4 deals with qualifying service. An employee who has rendered a minimum of 10 years of service and fulfills other conditions only can qualify for pension in terms of regulation 14 of the regulations. Therefore, the expression as would be due otherwise would mean only such employees who are eligible and have put in minimum number of years of service to qualify for pension. However, such of the employees who are not eligible and have not put in a required number of service years of qualifying service shall not be entitled to the superannuation benefits, though removed from service in terms of clause 6B of the bipartite settlement. Clause 6B came to be inserted as one of the punishments on account of the bipartite settlement. It provides for payment of superannuation benefits as would be due otherwise. The bipartite settlement tends to provide a punishment which gives superannuation benefits otherwise due. The construction canvassed by the employer shall give nothing to the employees in any event. Will it not be a fraud bipartite settlement? Obviously, it would be. From the conspectus of what we have observed, we have no doubt that such of the employees who are otherwise eligible for superannuation benefit are removed from service in terms of clause 6B of the bipartite settlement shall be entitled to superannuation benefits. This is the only construction which would harmonize the two provisions. It is well settled rule of construction that in case of apparent conflict between the two provisions, they should be so interpreted that the effect is given to both. Hence, we are of the opinion that such of the employees who are otherwise entitled to superannuation benefits under the regulations, if visited with the penalty of removal from service with superannuation benefits, shall be entitled for those benefits, and such of the employees, though visited with the same penalty but are not eligible for superannuation benefits, under the regulations shall not be entitled to them. Do not hear distinction between those employees or workmen who are who would be otherwise entitled, that is, they would have to put in the minimum years of service and would be otherwise eligible. They would be, even if removed or terminated, they would continue to enjoy the full pensionary benefits.
Now, just a moment, Mr. The, your penalties that can be imposed,
Yes,
is it there somewhere? It's in the discipline appeal rules?
yes, the discipline and appeal.
It would be rule,
But it is not in that compilation, which I have given.
no, it's major penalties, okay, minor penalties,
Yes.
ensure major penalties, severance.
It is there, my lord. I,
With the direction, but whether or not will implement.
it's 4I.
Reduction to in the time scale of a specific period with further direction as to whether or not officer will earn increments of pay during such reduction, compulsory retirement, removal from service which shall not be a disqualification for future employment, dismissal which shall ordinarily be a disqualification, so and so, so and so. Now, in pool, when 22 is being, that 6B,
Look.
sorry, 6B is being considered, the word used is removed.
Yes,
So whether this removed would be a penalty of removal or it
Yes.
would be a penalty of removal, dismissal, compulsory retirement, any cessation of service.
any of the major penalties, my lord, in my humble
That will
submission,
be covered
As are
by
there
this
in-
word. It's
yes.
not removal,
yes,
it's cessation.
it's a session of service.
Okay.
No, this is as far as Court's judgment is concerned. Now, my
Hmm.
lord, I place reliance on this judgment at page 87, my lord, which
Hmm.
specifically dealt with this issue.
Hmm.
And also the argument that, my lord, 43 to 48
Hmm.
would come into play.
Hmm.
And even if 22 is there, you know, that was negated, my lord, in this judgment. Ramesh,
That has to, because that's a different thing altogether.
yes, page 87 onwards, my lord, this
Hmm.
is. My lord, this case related to, my lord, the continuation of disciplinary proceeding after
After.
retirement. My lord. If I may just read from page 93,
Hmm.
para 7 onwards.
So,
Lordship, have it?
yes, you go ahead.
The questions which in the facts and circumstances arise for our consideration are: one, whether in terms of the rules governing the terms and conditions of services of the employees of the bank, it was permissible for it to continue the disciplinary proceedings despite the fact that the respondent attained the age of superannuation, and two, whether the High Court could have, in the facts and circumstances of the case, substituted the punishment imposed by the appointing authority and the appellate authority by its own. My lord, I will pray that your lordship comes to para 16, my lord, page 98. The last para of that page.
Hmm.
We may also at this juncture notice the relevant provisions of the Punjab National Bank Employees Pension Regulations 1995. Regulation 22 of the said regulation reads as under. Well, the regulation 22 is quoted. Indisputably, as a consequence of the order imposing the punishment of dismissal from service, the appellant would not have qualified for the pensionary benefits.
Hmm.
Our attention, however, has been drawn by Mr. Saxena to regulations 43 and 48 to contend that even for the purpose of withholding pension, a specific order in that behalf by a competent authority was required to be passed. Pension regulation is meant to be applicable where pension is required to be paid. It also provides for recovery of pecuniary loss caused to the bank from the pensionary benefits of the employee. Regulations 43 and 48 of the pension regulation are as under. Then below they quote this part. If I may come to para 17 next. The next page, page 100. Where a proceeding is initiated for withholding or withdrawal of pension, regulation 43 of the pension regulations would be attractive. But provisions of the said regulation, if read in its entirety, clearly go to show that an officer would not qualify for pensionary benefits if inter alia he is dismissed from services. Regulation
The
48
interesting
empowers
factor here, the word used is officer.
officer. Regulation 48 empowers the bank to recover pecuniary loss caused to it from the pensionary benefits. Regulation 23, Roman 3 of the discipline and appeal regulations must be read in conjunction with the pension regulations. Where the employees are pension optees, regulation 48(1) shall apply. In any event, if an officer is removed or dismissed from service under regulation 4 of the discipline and appeal regulations, the bank need not take recourse to regulation 48 of the pension regulations, as regulation 22 thereof would be attractive. We are therefore of the opinion that the High Court committed a manifest error in passing the impugned judgment. My lord, this is what the Supreme Court has said, that the once regulation 22 comes into play, my lord, no recourse to 43, 48, 46
It
required.
need not be.
So-
That's.
And
that's
here
like-
was a case where an officer, my lord, was removed from service of this very bank, my lord. And therefore, my lord, the Supreme Court has clearly held that
What is this Jagdishan for, the proposition?
proposition that, my lord, this argument that that there is a specific order required to be passed
Hmm.
for withholding the pension, and the pension
That
can
will
only be,
come when you are
why
dealing
I'm
with
saying, my lord,
43.
because this question arose because my learned senior is relying upon the interim order passed by Justice Bhuiyan. My lord, Justice Bhuiyan passed that order in the context of release of the gratuity. So in terms
Under the
of gratuity, YK Simla judgment is there, number of judgments are there, my lord. The section 4 of the gratuity act shall override these
Oh.
regulations. So, my
And
lord,
if you don't quantify the loss in the
Yes.
disciplinary or sorry, in the inquiry officer does not quantify the loss
Lodge.
and the disciplinary authority does not approve it,
yes,
subsequently you can't have a amount fixed
yes,
and then recover. It says you will have to quantify the loss
yes,
and thereafter only the gratuity can be
on the basis of that quantified amount.
quantified.
Unless an amount is quantified, my lord, the one cannot.
That is a
Well,
settled proposition.
This is that case, and as far as, my lord, the I learned one judgment of the Madras High Court, I have annexed at page 103.
That's what I'm asking you.
Yes, my lord.
That is for,
My lord, this point is for, my lord, the fact that an officer, here also there was a case of an officer, regulation 22, in fact, my lord, was invoked.
Hmm.
Now, the lordship will. But if I may have para 3, page 104, just to go through the facts for a minute. The factual backdrop leading to the filing of the aforesaid writ petition are that the appellant, while working as senior manager of the respondent bank, was placed under suspension on so-and-so in contemplation of the proposed disciplinary inquiry on allegation of misappropriation or embezzlement of cash to the tune of so-and-so. Charge memo dated so-and-so was, to that effect, was issued to the appellant. After proper inquiry, the appellant was dismissed from service by order dated so-and-so. Thereafter, the departmental appeal preferred by the appellant was also dismissed. There against a writ petition being WPC number so-and-so was filed by the appellant on the file of this court. This court, having considered all aspects of the matter, held that the punishment of compulsory retirement would meet the ends of justice, because the appellant and his family can lead some respectable life in the society with the punishment of compulsory retirement, rather than the punishment of dismissal from service, and as such, the punishment of dismissal from service was converted to one of compulsory retirement. Thereafter, the appellant made a representation to the respondents to treat the period of suspension as duty period and also sought grant of consequential benefits. Pursuant thereto, the respondent bank sanctioned a sum of rupees so-and-so payable in 2 installments towards gratuity. Sum of rupees so-and-so and the balance amount of so-and-so was also paid on the same day separately. In addition, provident fund to the tune of so-and-so with interest for 3 months as per Rule 21 of the Bank of Baroda Provident Fund rules was paid to the appellant on 4/11/2008. The other reliefs sought by the appellant were rejected. Being aggrieved, the appellant had come up with the instant writ petition. Now, the contention of the learned counsel for the appellant for this is that once the punishment of termination has been converted to one of compulsory retirement, the appellant is entitled to encashment of privileged leave under provisions of Regulation 32 and clause so-and-so of Regulation 38 of under Chapter 7 of the Bank of Baroda Officer Regulations, Service Regulations 1979. These are pari-materia provisions, fellow. In support of this contention, the learned counsel relies on a decision of the Supreme Court in Bank of Baroda versus SK Cool, so-and-so. The other contention of the learned counsel of the appellant is that in the absence of any express prohibition in service regulations for a grant of privileged leave in respect of a compulsorily retired person, the Bank of Baroda Officer Employee Discipline and Appeal Regulations 1976 cannot override service regulations, and as such, the appellant is entitled to encashment of privileged leave. Yet another argument is that when the appellant is entitled to retirement benefits and other terminal benefits such as gratuity, provident fund, and pension, As a natural corollary, he is also entitled to encashment of privilege leave as well. The appellant further claimed leave encashment and also treatment of suspension period as duty period. Now, my lords, the finding of the court, if I may take your lordship to my lords, page 107, paragraph 13. In the
Seven has not come. Mr. Ganguly, seven
page 10,
is blank. It's paragraph.
I should. be
You can,
having
you
a-
can, you can give me subsequently.
Yes, I think I should be having a copy. my lords, of
No, no,
this.
just tell me what is that. This man was an officer or
No, he was an officer. I was coming to that.
Compulsory.
portion. No, I have an extra copy.
you can,
He was an employee originally, clerical employee, then he promoted as officer.
in your case,
Yes, in one.
Para 13. It'll be the second last page.
okay,
Lordship. In the light of the aforesaid statutory provision, whereof the firm view that the writ court has rightly come to the conclusion that the appellant is not entitled to encashment of leave, benefit of privilege leave, pay and allowances for 6 months, and also the relief of treating the suspension period as duty period. In Bank of Baroda, the Supreme Court was considering a case of a clerk who was held as a workman. The Supreme Court found that the workman was entitled to the benefit of bipartite settlement signed by the Indian Banks Association and the bank's workmen's union with regard to the disciplinary action procedures. In that context, the following observation was made. Well, this part is there. Then if your lordship will come to just the third line from the last. This part, para 15. In the case on hand, consideredly, the appellant was a senior manager and his service condition was not governed under any bipartite agreement, which was the subject matter in Bank of Baroda. And thus the decision is of no assistance to the case of the appellant. In view of the foregoing, we do not find any reason whatsoever to interfere with the order passed by the writ court.
the Bank of Baroda citation is given somewhere.
Yes, Bank of Baroda given, and I have also annexed the
Oh,
copy.
SK Cool.
Cool.
Cool is been interpreted.
Pool is being interpreted that because he was a clerk, he was a workman. And in this case also, he was a senior manager, the case before the Madras High Court. And the writ petitioner before your lordship is also, was a branch manager.
Anything more?
Plus, my argument remains that.
Now tell me one thing, would he not be, say, we go totally, we reject Mr. Sarvadikari's case. Would he not be entitled to a compassionate allowance?
Compassionate
also?
allowance, yes, but that perhaps would have to
But
be,
he will not get any family pension there.
no. But for that, there has to be, he has to apply and
Fine.
be a separate process. for it.
Yes, continue. Anything more, Mr. Ganguly?
No, my argument remains that, regulation 22 is still very much on the statute book. It is automatic in its operation. Pari-material provisions are there in the, as far as the service conditions and payment of pension in other banks also, other nationalized banks. And the provisions operate not independent of the right to withhold, which is there in 43 to 48. Once there is a case of termination, dismissal or removal, similar regulation 22 automatically comes into. And bipartite settlement benefit would be restricted to workmen. That
And for that, you are relying on Jagdishan versus.
Look.
State.
My lord, in
Yes.
reply, only 2 words, my lord.
Hmm.
If, for argument's sake, if everything is ignored, if regulation 22 is accepted, all other regulations, bank circulars, IBS circulars, everything. But what about the bank circular of 2514? Is the bank not stopped from challenging this provision? That pension has to be paid and by the board resolution, competent authority should take the decision. When this provision has been there in the bank, why, if I ask this question to myself, why the poor employee of the officer will suffer if this regulation has not been followed? Where the bank has taken a decision that pension has to be forfeited.
You mean to say Radheshyam?
This
21,
circular, bank's own circular.
21, para 21 and 41 read with that 2014 circular. Read with 2014 circular.
Yes. 2014 circular, where specifically say that certain rules, regulation has to be followed before forfeiture of it. And the circular further said that even the disciplinary authority has taken a decision that it will be reduced or forfeited, it has to be got the sanction of the board. So how this circular will be overcome, apart from everything? And the regulation 1, 2, and 3J, officer and employees are the one and the same person. Entire Supreme Court decision has been specifically provided that section 22 is a dead letter. Completely a dead letter. If section 22 still operates, then of course I am out of the court.
No,
Yes, completely I am out. I have nothing to submit. But regulation 22 has been established by Honorable Supreme Court. It is a dead letter, throw out. And this has been thrown out. And by that about also this circular, how bank will work on this circular. That is troubling me, my lord. Why this circular has been issued? That means bank is also a social organization. They want to give a social benefit, which Supreme Court every time holds. That pension is a social benefit. And it has been specifically mentioned that if it is otherwise due, it has to be paid, provided there is no loss. The entire judgment of Justice Honorable Bhuya is only on that philosophy only. That bank has not sustained it. Otherwise, gratuity would not have been released. And this has not been appealed against. And bank has been released the entire gratuity. Even after 50% also, they did not. They admitted that yes, if your lordship kindly see the order of the Honorable Justice Suman San, they have specifically said that my learned friend, I thanks to my learned friend, he did not oppose. Gratuity should be released.
Mr.
Yes,
Ganguly,
how there will be two different
Mr.
things.
Sarvadikari has a point.
Yes,
To an extent that although it is a intermingling of both 43, 44, 46 and 22, the board of directors had arrived at a conclusion which they have put it as a desire. I know your answer would be 22 is not touched,
Yes.
even in spite of that, but
Yes.
still going up step further. Ordinarily, full pension be allowed to employee in case no reference regarding reduction in the terminal dues by the disciplinary authority in the final order is made. It's a circular of 2014,
yes.
right?
Good.
However, where the disciplinary authority makes a reference in the final order to reduce pension, that's a different thing altogether.
Okay.
But ordinarily, full pension, this is your own, the topmost body of your organization taking the call.
Yes.
Then what happened?
But as far as the circular is concerned, it was not followed by any amendment in regulation.
That's a different thing altogether. But whether that because it's a regulation created by the same authority,
Same authority.
same board.
Yes.
So whether this decision, like in the railways, they issue correction slips.
Yes.
And everything gets included in the IREM.
Yes.
You get my point? IREM is just a decision of the boards.
Okay.
So here also you have, it's not a statutory 309 rule.
Yes.
As Mr. Sarvadikari has said, but it has a force. We can't deny that. But whether this has been, we have to read that this has automatically gone in.
But since no amendment has been made in regulation 22 pursuant to this or any other resolution, merely making the resolution would not suffice. The board then would have to consider whether regulation 22 needs to be amended. Because regulation 22, if your lordship considers, has a salutary purpose. What is the purpose, my lord? That if an officer who commits a misconduct against the interest of the bank, he should not be allowed to get, my lords, away with
But the same thing will also apply in case of a workman who does the same mistake.
Yes. Now, the difference is would be this, my lord, that because there are two aspects. One is, my lord, the status and responsibility of the officer. And the
Misappropriation, the Supreme Court, even if he is a clerk, or the topmost man, Supreme Court said,
Absolutely. Absolutely,
that's the end of the matter.
absolutely. But
Does not
unless-
make a difference between a officer and a workman.
Yes, but unless and until, my lord, there is a similar bipartite settlement or any other, my lord, amendment to regulation 22.
Was this aspect never considered?
That's not
Even
to
in
my-
Chennai, Madras, they went with the thing that you are an officer.
Yes,
And you were telling me that provision similar to 22
yes,
was put to challenge.
yes, my lord.
Which is that judgment?
But that I cannot recall at this moment, but I have, during the course of studying all this, my lord, I came across certain.
Give me that
judgments.
judgment.
Perhaps directly did not deal with regulation 22 as such, but
That,
There
that
was-
prescription there with regard to a bank
I'll try to.
covered by the bipartite settlement.
I'll try to. No,
Within that
but
50.
no, that doesn't cover bipartite.
No, I'm not on that. I'm not on that.
Regulation 22, similar
I'm
regulation.
not on that. Regulation 22 of a bank
Yes,
whose workmen are covered by bipartite.
yes.
Whether in that context, maybe an officer, maybe in a workman, what was the decision? Can you just
I'll try to.
elaborate on that? If you have read it somewhere,
Yes, because
I mean, I
I
also
did
got
come
it some-
across certain.
I
judgments.
got it somewhere when I was last time research.
I
but
think,
somehow I missed it.
Either Madhya Pradesh or Punjab, I'm forgetting now, but the regulation was put to constitutional challenge. Division bench held that we are not going into this aspect at all. We do not find anything. So it is not a very philosophical, permits me, not a very enlightening
But,
judgment.
but one
But
thing.
it was,
that-
but it was
that-
addressed.
That thought process of the bank,
Not-
that although the directors had taken a call, that they would use the word desire, but
Desire.
be that as it may, that this should be changed.
Yes,
Whether that was in the context of purely 23 or 43, 44, 45, 46, because
Yeah.
the last part creates a doubt.
yes, my lord. And moreover, my lordship will see that that circular focuses more on the gratuity part.
That
Gratuity part is there
gratuity
because,
is entitled,
because if there
because
is
there
no-
is no recovery from.
Yes, because if there is no section 4 of the gratuity act, my lord, then the regulations take away the gratuity right also. So, my lord, in that context.
That's why
perhaps
this court held that section 4 will have prominence.
Have, an override. And that has been, my lord, confirmed by the Supreme Court in several judgments.
Mr. Sabadikari, anything more?
Yes. I have already told you that if everything is ignored for argument's sake, of course it is difficult to ignore, but even then how this board resolution will be
I
ignored?
got it.
Why? Why by a
Now,
bank,
it is-
whatever has been taken away by section
No,
22,
it
the
is my
bank
honor-
itself has returned it to the employee.
Now it's my honors to now harmonize everything back.
Yes,
Mr. Sabadikari, you're coming from Calcutta.
yes, my
You
lord.
need not come. You need not come. I'll get this matter again listed on Friday. Your colleague here will inform you. You can come online.
Phone,
Online.
online, yes,
You can
online.
come online. If there is any query, I'll just ask you. If not, I'll reserve the judgment. I'll read it in between.
If
And
anything, they are online.
Online, you come online. You did not take the trouble of traveling. At
This Friday.
this Friday.
Okay, ma'am.
Because from next week, I'll not
I
be
am
here.
grateful.
So
am grateful,
I'll
my
have
lord.
time to.
I am grateful for giving me a patient hearing, my lord.
It's
If
my,
anything
my-
is there,
my-
my junior will take this line from this and I will come
Ah.
on.
who is your assistant conciliary?
Come in.
Friday, give him a link. Okay? Friday, I don't know when I'll sit, maybe second half, or maybe first, second half, 2 o'clock maybe. Give him a link. And if there is any query, we'll ask.
Online to me, am I?
He'll do it. And Mr. Ganguly, if you get that judgment,
I'll
if
try
you
to.
get that judgment,
I'll try to.
give a copy beforehand to
Yes, I'll.
Mr.
give you-
Ganguly's.
Yes, this judgment regarding Madhya Pradesh High Court.
Yes.
Madhya Pradesh. Anyway, let me see, because even if it is Madhya Pradesh High Court, otherwise Supreme Court overruled it. As your lordship noted.
Because this was something different. This provision bipartite,
Yes,
Yes.
this is something different from your normal service. matter.
yes, yes.
Normal service matter, removal, dismissal, sub-gap, finished.
Yes.
Finish, right.
But here, an angle, a different
Different.
system has been
And
given.
the definitions are all slightly.
And one more thing, my
That's
lord.
why Mr. Sabadikar is saying, that by the regulation, you have also equated me to be an award employee.
Yes.
We'll see.
And another thing, my lord, sorry to
No,
again
please.
disturb you. My learned friend has told, and your lordship also observed, that whether this removal is a cessation. If it is a cessation, this word will not be there. Removal without any disqualification from future service. That
No.
means he can come back to the bank again from future service. So it is not at all a cessation.
Mr.
Cessation is dismissal.
Mr.
That way, anything is cessation.
Mr.
Compulsory
Bhavani
retirement
Kari.
is a cessation, voluntary retirement is a
got
cessation, removal is a cessation, dismissal is definitely a
I got
cessation.
it, I got it, but
Mm.
fortunately, unfortunately, basically, the service law concepts are judgment law. And if you see from the word go, there was a distinction three, even in the Constitution 311, the word used is removal, dismissal, compulsory retirement. All the three means a cessation of service. But if you look into to make a distinction between a dismissal and a removal per se, they have added the words
Without any
with-
disqualification.
So normally it has now understood that if it is a removal, you lose everything, but your further opportunity for a service,
Not
if some employer wants you,
right,
it's not a bar. But dismissal was a bar. So that
Completely.
is only to the extent to show that the intensity,
right.
of the penalties.
Intensity, right.
Intensity
Yeah,
of the
absolutely, I
penalties.
agree with you.
you have done a major misconduct, you are entitled, okay, removal. But something which is beyond that, that is dismissal. And something, okay, he has done it, but circumstances are there, compulsory retirement.
Right.
At least this court understands it in that
Yes,
manner.
no, it's absolutely, I agree with you. But in
Friday.
this type of thing, everything is a cessation. Once he is going out of the bank, it is, or any organization, it is a cessation.
Okay.
Grateful.
By slip did it. I don't think. Thank you.
Grateful, my lord.
Friday, he'll give you the,
Huh. You give me the link?
Mr. Ganguly, if you get it, give it to me on Friday. That. Supply the task, Manu Boyeshi did it. Supply to this.
Item 8, top of the list.
Lordship, I have got the affidavit filed by the respondent. I have, so today I just now have got it, Your Lordship. So whatever does they have said,
You want to counter that?
yes. Because Lordship, in doctor's advice, there they have mentioned one J. Boyser,
Okay, fine.
that has been corroborated by medical,
Mr.
BN Gogol.
Mr. S.K. Chakraborty, learned counsel, appearing for the respondents, has submitted that an affidavit in terms of the earlier order of this court dated 34/2024 has been filed today, and a copy thereof has been furnished to the learned counsel for the petition of Mr. B.N. Gogoi. So, Mr. B.N. Gogoi submits that in view of the contentions made, in view of the contentions made in the said affidavit, he would be required to file a rejoinder therewith. Also, accordingly, list this matter when,
After 2 weeks.
after 2 weeks, on a date to be fixed by the registry, this matter shall not be treated as a part anymore.
I'm developing.
Delhi Coast list, motion item 6.
Please, Lordship. Lordship, I am paying for adjournment also, Lordship.
When-
Instructions received your
Give me. We had given Ms. Wajida time
two times.
to just address us on the issue.
Lordship, the leading engaged council is out of station, Lordship.
Who is a newly engaged?
Lordship, NS Mazhab, Lordship.
We only wanted Ms. Wajida to be here. And Wajida and Mazhar Bhuiya from the same chamber.
Lordship,
So there is no question of new engagement.
Lordship, Al Wajida is in
Oh,
hospital,
no,
Lordship.
same
What happened?
yours.
Her mother is seriously ill, Lordship.
That you tell me, I'll answer. Monday, Kumbar, no? Today is Monday. Okay, it is submitted at the bar that Ms. L. Wajida, Learned Counsel for the petition is not, on account of personal inconvenience, is not present in the court today. Accordingly, an accommodation is sought for in the matter. Also, list this matter again on Thursday. Who not writing it? Full or right? 16. 16/5.
Lordship, some other names.
16/5.
Already instruction placed, Your Honor.
Please, the instructions received by Ms. P. Das, Learned Standing Council, Secondary Education Department, is kept on record and marked as X for the purpose of identification.
Deeply obliged.
Admission item 7.
Mr. Das,
Yes,
today.
3 hours.
You are here on Thursday.
Yes.
What I do is I'll fix it as the first item.
Can
To
we
complete
try
your-
on Wednesday?
Wednesday, okay, fine.
Because after there will not be much matter, motion matter.
Motion matters one day,
So
Wednesday. Budbar already. First item, top of the list, first item. What are the head level? What are the say? What are the- Due to paucity of time, the matter could not be taken. Could not, with the submissions of Mr. H.K. Das, Learned Counsel for the petitioner could not be concluded. Accordingly, list this matter again. It will be
it will be 15.
15/5/2024 as the first item.
Mile.
But
Highly.
because you will have to finish it by Friday.
Yes, my lord. But I have only 3 charges
Three
I have
charges.
finished.
Yes.
3 are there.
He'll do it on Wednesday.
Yes, my lord.
If you can conclude on Wednesday, fine. Otherwise, we'll take it up on Thursday.
Yes, my lord.
Mile.
And Thursday we'll conclude it.
Then next week we'll.
Huh?
From next week, our some.
Huh?
From next week.
I'll not be here. Come to Arunachal.
What's
Next week, nothing.
next this week?
Thursday.
That's right. This week we'll finish it up.
Then, okay.
Wednesday, he'll conclude. He has
Yes,
only
yes.
3 charges, but the rest he has already given the written thing.
Yes, no.
You finish it on.
Yes,
Need
yes.
me lot 20-30 minutes time, it will be over.
We'll give you the first matter.
Yes,
Thereafter, we'll go to the other.
fine.
Right?
Much of that.
Must.
Deeply.
Pass number 2, Vaishali Bol. Pass. वही तो ছবিটো হেৰি যাব ইয়াত মেজৰ মতো আৰু পাৰ্টনাৰটো দি দিয়ে সিহঁতো 22 তাৰিখে কৰিব লাগিব পাৰ্টনাৰটো 15 তাৰিখ Five, seven, eight. Yeah. Here. The- Jadi, jadi निर्मित link. एक इथे समजा द्या. हा साइट बघू ना. इथे माझे साबण दिले.